Hi everyone. At the end of the last video, I was just talking about that important skill of being able to listen and take notes at the same time and multitask enough to think about your follow-up questions. And before I move on to talk about the second topic explored in Unit 4 here with the second part of communications, I wanted to just finish up and talking about that last bullet point here, which is end and follow up. It's really important when you finish meeting with a client or talking to the client over the phone or really with anybody over the phone to appropriately end the meeting. Don't leave anybody hanging. Make sure all questions have been answered. And if you happen to run out of time during a phone call or during an in-person meeting, that can happen, but that's a really good time to take out your pen, or if you're typing notes, make a note in there to yourself that you weren't done and that there's more follow-up questions or something more to discuss. And then figure out with that person, for example, a client, where is how you're going to follow up with that client. What is the next step? What is the next stage? One of the most important pieces of information that I'm going to stress to you throughout this semester is not to leave your clients hanging. I know that's really hard because we are really busy and we know what's happening with the clients' cases, but remember, our clients don't know. So if you're meeting with a client, let's say on a Monday, and it might be a month or 2 months until the next stage or next important event in that client's legal matter, make sure the client knows that and say, listen, you may not hear from me for a couple of months, but in the meantime, if you have any questions, feel free to reach out. Or you might even say something to explain that the next 6 months are going to move really slowly because there's some work being done behind the scenes in terms of maybe gathering documents, gathering evidence, but that you'll update the client at an appropriate time in a couple of months, just so you don't leave that person hanging. So make sure you follow up with whatever it is that you're finishing the meeting on. And by the same token, I also should mention, if you've promised to send documents, make sure you send them. If you've promised to follow up with a piece of information, make sure you do that. So my advice is to write down a note to yourself at the end of each meeting, what you need to do. What are those action items that you take away that you want to make sure that you accomplish before you next meet with this person or have another obligation? Okay, that is the end of this part, which is all about the oral communications. But of course, we have to talk about written communications, because there's not a day that goes by in a law office where you are not writing something, writing multiple somethings, and reading somebody else's written communications. There are a lot of documents in the law office. So it's impossible for me in one PowerPoint to really go over all the different types of documents that you would see in the law office. Here, we're going to end up stressing and talking about specifically letter writing. But before I get into letter writing, I just want to highlight some of the words that I have here, because they are universal for any particular practice area, any work that you must be doing, which is any type of work that you're doing, any type of document that you're drafting. Before you draft any document, I want you to keep these principles in mind. First, who is the audience of this document? Who is it going to? Who am I writing it to or for? Number two, what is the purpose of the document? What am I trying to accomplish by drafting this? And that will give you number three, which is what is the tone of my document? So just to give you an easy example, if you're writing a letter to a witness confirming a meeting coming up, then the audience of the communication is the witness, and the purpose of the document is informative. So that's just one example. It's really important to keep these in mind when you begin drafting, because you always want to make sure, and this is what we'll go through, that your writing is to the appropriate person and accomplishes the purpose that you want. We don't want to go off on tangents. We want to stay focused on what is the goal of that document, and we want the document to have the appropriate tone for that purpose and that audience. So kind of keeping those in mind every time you sit down and draft, you won't go off track. Okay, your book does, I think, a pretty good job highlighting some of the important tasks and skills you want to keep in mind when you're doing written communication, but let's just go over some of them together. Much like with oral communication, any type of drafting, and again, we're going to focus here on letter writing, is preparation, preparation, preparation. We don't just open the computer and sit down to write a letter. We need to have some information and content with us first before we can draft a letter. So I come back to the two principles I said before, which is audience and purpose. So keep in mind, who am I writing to and what is the goal of my document? Some other important pieces to keep in mind, and actually I'll just sort of diverge from my own PowerPoint here, is that when we talk about letter writing, or again, really any written communication, but I'll focus here on letter writing. In addition to purpose and audience, the other two pieces that I just want you to have in your mind is that anytime you're doing drafting, we are doing two things at once. We are writing content, so like the substance of what we're writing, what's going in that body of the letter or the motion, what's the core of the message that I'm sending. But we're also focused on the formatting of the document. What is it supposed to look like? In the legal profession, a lot of our documents are, they have to follow a certain format. Like court documents are pleadings and need a caption and a signature block at the end. An appellate brief has multiple sections that is required in it. Letters, for example, have a letterhead, an address that we call the inside address. They have a regarding line, and we'll go through all of that. So we're really, as we sit down to write, we're really doing both. We're formatting the document and we're focused on content. So I'm not sure how you all work, but my brain really only allows me to work on one part of that letter at a time. So I might do a letter where I might just sort of outline the format of the letter. I've got my letterhead on top, I've got my inside address, I've got the body just sort of outlined because I want to make sure that my document meets all those requirements and therefore looks professional. And then separate from that, my brain will then focus on the content of the letter. Sometimes it might be difficult to do both at the same time. So it depends on how you work. If you can format while you write, good for you. I need to do each one at its own time and then kind of blend them together. So both think about the content of your writing and what the formatting of the letter looks like. All right, so we've talked about some general preparation skills. I also just want to kind of go over some other points, just sort of the pre-writing part is, gather in front of you all the information that you need for the content. If you need dates, if you need documents that you need to reference, don't guess about them, have all of that information in front of you. So think about that before you begin to write, so then you're not scrambling, looking around for some information that you need. Remember when it comes to your audience, that now that you've been through this program and you've taken these classes, you are sophisticated in the language of the law. There's a lot of terms of art that you know. There's words that you know the meaning of and the context of because you have taken legal classes. But most of our clients or our witnesses or our third parties with whom we interact, they haven't. They're experts in their own areas, but not what we're experts in. So as we begin the drafting of a letter, try to avoid using language that can be confusing or vague or undefined for someone that's not familiar with the language. There's some really good examples of your book of words to avoid in the letter. Even something like herein or hereinafter can be really confusing and misleading and then end up, we lose the focus of our letter because we're using a lot of legalese or terms that are not defined. Let's also talk about being accurate and specific in the context of our writing. So when we're writing for a particular purpose, in order to accomplish that purpose, we need to be accurate in what we say, and we need to be specific in what we're talking about. So we don't want to use general things like a car or the car. We might need to actually describe which car it is. Or if we're referring to an email, we may need to refer to the specific date of the email so that there's not ambiguity, confusion, and then again, we don't accomplish the purpose of our writing. Couple other things just in general in terms of preparing to write. Remember that if you're writing to a client, there might be a particular privilege involved, like the attorney-client privilege. So just be aware of that when you're writing. I put the words paper trail here. So remember that, and I think you guys all know this, but once something goes down in writing, whether it's a text message or a formal letter, it exists in the world and it doesn't disappear. You know, in the olden days, there might be a fire that burns everything down, but now we keep everything digitally forever. So remember that anything that you put down in writing is part of a record. It's part of a paper trail. So while it might be that communications between the attorney and the client are not discoverable because they're protected by a privilege, other documents would be. So if you write letters to witnesses, to third parties, to government agencies, requesting information, all of that forms a paper trail that is discoverable. So just remember that in terms of your use of your professional tone, that people that you don't mean to look at this document may see it one day. Also, remember to talk with your attorney about the documents that you are permitted to sign. You can absolutely write letters to the client, and you will, and opposing parties, and potentially the court and witnesses. The major document that paralegals cannot sign in terms of letter writing are opinion letters, because paralegals are prohibited from providing the legal advice. Those documents must be signed by the attorney. You can do a lot of the drafting of it, you can conduct the legal research, but the actual providing of the legal opinion needs to come from the attorney. Another piece of information to go over before you begin writing or even as you're finishing the letter is, how is this letter getting to my client or to the third party or to the witness? We call this the method of sending. There are a lot of ways to send mail, right? You can send it by US mail, you can send a letter by FedEx, you can send it by fax or even by email. So in our letters, we often designate right above that inside address the method of sending. It goes back to that record keeping way. We take a copy of that letter, we put it in the correspondence file, and now it'll say in it, via email or via Federal Express, and that's our way of knowing how we kept track of our own mail so that we have a record of it. Lastly, in terms of this slide anyway, if you're going to put an enclosure, and what we mean by that is if you're going to send a document to somebody through the mail, we call that an enclosure. Nowadays, I think we're all more familiar with the word attachment, because something we want someone else to read, we attach it to an email. That's an attachment. We didn't call it an attachment when we sent letters by the mail. We call it an enclosure. So if you are sending a physical document in the mail to somebody, make sure your letter designates that it has an enclosure in it, and that way the recipient knows to be looking for something that's included there. Much like when you would send an email and you say, please find attached. Same idea, except we call it enclosed. So attachment for email, enclosure for actual mail. And by actual mail, I mean putting it in an envelope of some sort and getting a physical copy sent. My last tips in terms of writing letters is really going back to the formatting. I'm not going to spend time on the PowerPoint repeating all the steps that are set forth really nicely in your book at about a page 108 until about 112. And then there's actually a sample letter in there. And you are going to have an opportunity to draft a letter as part of your homework. But I just want you to take some time and look over the formatting of the letter. Understand that the letterhead is the name of your firm. The inside address is what we call the person to whom you're writing. A couple of really critical pieces of advice here. If you are writing to anybody, make sure you know the spelling of their name and their title. Are they the corporate vice president? Do they like to be called by a certain title? Do they have a junior after their name? Make sure, and if you're not sure, just ask what the spelling of somebody's name is. I mean, I get that all the time. Also, remember a proper salutation. Dear so-and-so, make sure you're speaking in that professional tone. A couple other pieces of advice: identify yourself in the letter that you are writing as a paralegal so that they know who you are and what your role is. And last but certainly not least, proofread, proofread, proofread. My best advice is either have somebody else read the document that does not expose privilege, or read the document backwards. That's my best advice. All right, happy letter writing this unit.